Hi everybody, I want to talk about the dangers of wills that are not prepared by a professional. Okay, just a recent story that happened to one of our files is that a will was drafted. We don't know, we weren't involved at that point. Drafted by somebody, then it was witnessed by two people, which is correct. And what was not correct is that the will wasn't initialed properly by the deceased, okay, the testator at that time, right? And also one of the beneficiaries was also the witness. So right away, and it was first time in my practice when I had to deal with it, because I attended at the court and I asked them what will happen, what do I have to do in this situation. So, and I was advised that the person who was the beneficiary and who was also the witness lost all their rights to be a beneficiary. So that's automatic. So this is a very important lesson for those people who want to do the wills at home. Like even if you type it up or have it downloaded from online or something, right? And then you have your kids who are beneficiaries, let's say, be a witness, they will not get, or the wife or whatever, whoever, they will not be entitled to that gift from you. So you need to find people who are not beneficiaries to be your witness. And then you have to make sure that if it's typed document, you have to make sure that every page is initialed by two witnesses and yourself if you're the one who is writing this will or signing this will. So at least do that. And also, very important part is the Affidavit of Execution of the will. I think that's how it's called. There's a form online that you can download, and you should have it signed, that form right away. Like it's not the person who signs the will signs it, it's the witness. One of the witness is making a statement that that witness and the other witness that were there, they are not husbands, wives, partners of husband and wives, whatever. They're not of any beneficiaries, so they're not related to beneficiaries in that direct relationship, and that they were present when you were signing it, and they're witnessing it, and that they know you, and that they, or maybe they identify you somehow, right? They don't maybe know you as a friend or whatever, but they identify you, and that you were in a capacity, a proper capacity to sign that will. So that paper is very important. In our practice, when we sign wills, we right away draft it and then we sign it, that affidavit, so it's attached to the will. Because once you leave our office, let's say, that will hopefully not going to be needed for another many years, because you're going to leave, and then only when you die, let's say 20-30 years from that meeting, your executor will go to court with this will, and they will need this affidavit. They're attached because then they're making a proper preparation for the documents to court, and this one of the documents has to be attached to the package, be included in the package. And actually what happens, like if I maybe do a pretend will one day, if I'll have time for that, I will show you how it's all assembled, because you do the affidavit and then you put a stamp at the back of the will, and you'll write that this is the exhibit to this affidavit. So there's several steps that needs to be taken. And imagine that 30 years passed and your executor is coming to a lawyer to submit these documents to court, and there's missing paper, right? Missing paper. And then they have to find those witnesses who witnessed your will. And that could be a problem because they might die by that time too. They might leave the country, retire in somewhere in a different country, and then I'm sure there will be a solution how to do it, but it's not going to be just very simple. So therefore it's better to do it all in advance at the same time, I would say, with a will. So in our case, when the initials were missing and when a witness was also a beneficiary, we had to do additional affidavits from them explaining the situation, why it happened, why initials were missing, and all that stuff. And everything worked out. It just was a little bit extra work and extra trips to court to file stuff. Nobody had to appear, luckily. It's all was through the paperwork, so I just had extra meetings with clients, explanation, drafting, signing, and submitting to court. And the will was probated, so it wasn't like invalid or anything. It was just not properly done, and we had to fix it now. So in order to avoid that, I recommend people get professional help, because while internet is a great resource, I love it myself. I'm constantly checking something there, but because I have a legal training, I can compare information. I know maybe where to go, like to a regional source, and then draft something that will work, instead of you guys going, let's say, online and just downloading some will that you think is gonna work. And that's the reason I never witness anybody's wills as just as a witness, in terms of like notarizing it. Some people say, okay, I drafted something, can you just be my witness? I don't do that, because I don't want later on being involved in any litigation, saying that maybe I gave them legal advice, or maybe that person didn't have a capacity to sign it, and it's just not worth it. So that's my advice about the wills. Very important document to have. I know nobody wants to do it. I don't even like to do them, because it's constant thought about death. It's depressing, but at the same time, when you know that your family is protected and they don't have to have any issues with court or between the beneficiaries and all that stuff, so just have it done and forget it. And then once in a while review it. If the situation changed, let's say, I don't know, someone died, someone got married, new person in your family born, like new kid or whatever, right? It could be many changes in your life within a certain period of time. So if you still have a capacity to deal with that, you can update it. So that maybe comes the time that you can update it, because you lost your ability to do it, like you have got dementia, and that's it. Nobody can even sign it with you, right? So therefore, maybe we recommend every 3 years to think about your situation, what's changed. Maybe you have new grandchildren, maybe, I don't know, maybe you've got something more in terms of financial stuff, and you want to divide it differently between or among your children. And just think, you can update, or you can just do it all over again, the new will. So you just revoke the old one, new one. And I always recommend to go to the same lawyer who helped you with the first time, because they do have your, let's say, if you want to change something very quickly, they do have your electronic version of your will, so they can go and change one paragraph, add another kid or whatever and then reprint and sign it should be much cheaper than going to a new lawyer. But I have to say that I have people who I sent to other lawyers who did their wills, and they come back to me saying that it's not cheaper, and they don't have that copy, electronic copy, and they want me to do their will. So that's that. Okay, I'll see you again. Bye.